I have been living and breathing the problem of short-term rentals for the last 8 months to the point of obsession. And not working with Karen Eon. I met her only once, in fact. And so I think I have some viewpoint to give you on that aspect. And I thought that might be important because does Ms. Eoff, as an elected official, doesn't she drive a unique benefit, right? Or gain any advantage compared to the rest of the class of people affected by the legislation that she's drafting. And in my opinion, this is not the case, and I will say why this is not the case. I got into the short-term rental problem because in my neighborhood there's a lot of short-term rentals, and we've tried to find sort of a solution, look at it from various angles. And so I've looked at a lot of the cities on the mainland and tried to understand, are there any nationwide best practices for short-term rentals? And so I looked at 14 different cities and collected information about the different components of a rental ordinance. So if you were to sit down, you said, we need to regulate this because there's this is going everywhere. Most of the tourist cities on the mainland have that problem now. And so Ms. Eoff, when she went out originally, she actually wasn't the first one to draft. It was the mayor's office. And I noticed because I first talked to the mayor's office, and they put me in touch with her. So Roy Takamoto from the mayor's office drafted this bill originally. He presented at the Rotary Club back in November. And he then worked with Drew Kanua and Ms. Eoff to introduce it. But anyway, stepping back from this particular bill, looking at the 14 different cities, what are the components that would be in any ordinance that anybody could introduce? And basically what you find if you look at this is that half of the 14 communities, most of them that are in tourist areas, what they tend to do is they limit the number of short-term rentals by geography. It kind of makes sense if you think about it, because you want to avoid short-term rentals spreading into residential areas where they compete with homeowners, and where like capital is flowing in, and people are buying up lots, and then you have commercial activity competing with private mortgages, essentially cash buyers competing with, private mortgages. So half of the cities limit either by census tract or by zoning. And what Ms. Eoff is alleged here is that she has a unique benefit. I think what Mr. Guzman alleges is that she has a unique benefit from the fact that her unit, which is in the Kona Islander Inn, happens to be in a commercial zone, which is, not regulated. And I mean, where it's in the bill language, it says commercial zones, are not going to be regulated, and the other areas, the residential and the ag zones, would be regulated. But this is exactly what half of the cities on the mainland do. And it makes total sense, I mean, you wouldn't regulate commercial zones because you want to push the commercial activity into those zones, that's they're zoned for. And so I think they're really, Mr. Guzman is waving a red flag, but I don't see anything there. Just stepping back and looking at this from other communities. To give you an example, Charleston limits the number of rental units to 1 per lot in a residential neighborhood, but 9 in non-residential. So they also restrict it in commercial areas, but they allow much more. Austin limits non-owner-occupied short-term rentals to 3% of the housing units in residential districts, only there. So again, Ms. Eoff's unit is not in a residential unit, so she'd be okay in Austin, she'd be okay in Charleston, half of the cities. Okay, that's I think the point I was trying to make. I think Ms. Eoff misspoke, she made a mistake, but her property is located in a commercial zone, so almost under any STR regulation that anybody would draft, it would be permitted. Then I also went to the planning department and to real tax and actually looked, you may have also done this. So I have this as supporting documents at her unit. She purchased it in 2005. It's the unit 205 in Kona Islander Inn. She's been paying the highest tax rate in the county since 2005 on it. The so-called apartment tax rate, that's actually higher than the commercial tax rate. It's a slightly lower. And It's zoned V.75. I have it here from the planning department. And so by all means, I don't see any problem with that, by all means. Okay, so this is, I leave this as supporting evidence. This is the presentation that Mr. Takamoto gave to the Rotary Club. It has essentially in the most important dimensions of the bill in it. So you can see that this was before the bill was drafted. I also, I think Mr. Guzman is trying to get everybody to focus on the accusation rather than the facts. And one other problem is that in this whole short-term rental area, there's so much capital in it that, when people have money in the ground or planning to build something, then they become very defensive around it. And so this is, you see this everywhere, And one more thing I wanted to say is I know Karen Eoff, not personally, but in a different context, and I think we may want to consider this also, Ooma. So Ooma is this big parcel over in Kona where 2,300 homes were going to go into what was called Ooma Beachside Villas. And I testified in a hearing there against this development. I thought it was crazy to take that open oceanfront land away from the community because, when you drive from the airport to town, that's what you see. And you don't want that to look like Honolulu. And I learned later that Ms. Eoff was instrumental to get that piece of property into the land fund. And I think people will forever be thankful for that. So please, no matter what discussions, Ms. Eoff, she did a huge favor for the community that will take a long time to repay. So that's all I have to say.
Aloha kakahiaka.
Aloha kakahiaka, Chair. My name is Miley David. I'm a colleague and council member and also a friend. And I come before you, this board, to testify in those capacities. And I'm testifying on item 5A. It's very unusual sitting here on this side and addressing, but it's my privilege to do so. So I'm going to read my testimony because I think there's some points that I really want to make that I would not be able to remember it. So I appear before this honorable body in support of Council Member Eoff as a colleague, a community advocate and friend for more than 30 years. My testimony will focus on the duties and responsibilities in our role as the legislative body of the county and the exceptional personal and professional character of Ms. Eoff, and my firm belief that Ms. Eoff should rightfully be allowed to perform her duties and obligations as a legislator and found not to be in any conflict of interest. The Hawaii County Charter provides that legislative power of the county shall be vested in the county council, and that its primary function shall be legislation. This mandate is separate and distinct from that of the administrative branch. Although the council is charged to enact policies for the best interest and benefit of the people, there's always the potential for legislation that comes before the council to be controversial to some degree. Given that reality, we as legislators must be diligent, honest, and collaborative in every piece of legislation we propose to ensure as best we can that a proposed law brings balance, fairness, and enhances the quality of life for the people of Hawaii County. The Hawaii County Charter, Article 14, Section 14.2, which sets forth the standards that will constitute a conflict of interest. I believe in this situation, the question of standard that may have some applicability could be sections 14.2b and c. The question is whether Ms. Eoff is using her position as a council member to get special privileges, consideration, treatment, or exemption beyond what is available to every other person. I say no. Or is her ownership of a condominium unit incompatible with Ms. Eoff's properly discharging her duties as a council member? I also say no. Or does that ownership impair her independent judgment when performing her official duties? Again, the answer would be no. Therefore, in my humble opinion, both standards that could be applied to determine a conflict in Ms. Eoff's case have not been met. Also, Hawaii County Code, Chapter 2, Article 15, Sections 283B and D, and Section 284A1 and 3 also contain specific sections pertaining to the Code of Ethics. I will not address the Hawaii County Code provisions because those have been fully addressed by Ms. Eoff in her petition, but I totally support her position on that also. So from a professional and personal perspective, it is my conviction that Ms. Eoff has been diligent, honest, and collaborative in every legislation with which she has been involved, and especially so with the proposed legislation regarding short-term vacation rentals. I would also note that Rule 11 of our Council Rules of Procedure and Organization, Disclosure of Interest, provides that the proper venue and timing for a council member to make full disclosure in writing of any potential conflict of interest is to be made before the chair of the council. So although I've expressed my belief as to Ms. Eoff that there appears to be no clear and undisputed conflict of interest in my mind, in an abundance of caution and with sensitivity to public perception, she has chosen to seek the advice and direction of this board. And I honor her for that. Ms. Eoff has always conducted herself and performed her duties as a legislator and community advocate in an honest and lawful manner, always with justice and fairness in mind. So in closing, I respectfully urge the members of this board to find that no conflict of interest exists with respect to Ms. Eoff, and I really thank you for your time and allowing me to express my thoughts. Mahalo nui.
Mahalo nui, Councilwoman. Roy Takimoto, please. And again, sir, if you can introduce yourself and let us know the agenda item you wish to testify on.
I'm here to address agenda item 5A. My name was mentioned earlier in one of the first testimonies as one who has worked on this draft Bill 108. And I'm here to confirm that our office, the mayor's office, has held this vacation rental issue in high priority, and that we started working on this bill from last year. We sent a letter to your board dated March 14th. Nancy Pisicchio, one of the executive assistants, drafted the letter. And in that letter, it outlined the mayor's office role in developing the draft bill. So Nancy and I were the ones who did the background research and defined what a vacation rental is, which means we narrowed the target of the regulation to single-family dwellings, not condos or apartments or anything like that, single-family dwellings where the owner was not present. So in a hotel or condo or hotel, you have someone at the desk checking people in. This was not the intent of the bill. The bill was to address single-family dwellings that were being rented on a short-term basis, not in residential, that were primarily in residential areas causing problems. So that was the target. We wanted to control where the short-term rentals would be and direct them to more appropriate locations, which would be resort areas and general commercial. We then requested the Kona legislators to see if they were interested to introduce it, knowing that Kona is where a lot of the short-term rental issues were very controversial and heated. And they consented. And they did some minor changes, but I would say the bill as introduced, we would have introduced basically the same thing, without much substantive difference from as it has been introduced.
Thank you, Mr. Takimoto. Appreciate it. Mr. Joseph Kamelamela, please.
And members of the Board of Ethics, my name is Joseph Miller. I'm the Corporate Counsel, County of Hawaii. I'm going to be speaking on petition number 20183-03. Most of the statements that I'll be making would be based on the letter that I just submitted this morning. That's addressed to the board. In this petition, Councilmember Karen Eoff, District 8, Vice Chair of the Council, Chair of the Planning Committee, requests a determination from the Board of Ethics as to whether she can introduce, discuss, or vote on proposed Bill 108 that regulates short-term vacation rentals of residential units in zones not currently specifically zoned for or designated for hotel and resort-type uses. Bill 108 serves to provide the county with the tools to allow short-term vacation rentals to operate on the island of Hawaii and to regulate them and to protect our residential neighborhoods, because as we had read in the papers, there has been a lot of controversy of many of certain areas where there has been an influx of such short-term rentals, which actually is taking away, some rental units that are needed for people here. Now, for the information and reasons that I will state hereafter, we believe that there's no conflict of interest that should refrain or recuse Councilmember Eoff from deliberating or voting on Bill 108. Councilmember Eoff, true, she owns a unit within the Kona Islander Inn, which is designated for hotel uses by the Hawaii County Zoning Code. Bill 108 would not change the current zoning for Councilmember Eoff's unit, but she would have to register the use of the individual unit as a short-term vacation renter. And neither will she receive any additional land use privileges of her unit upon passage of Bill 108. The reason why I'm here is so that people would have a better understanding on how the county council typically operates, and so the county council, they determine through its rules and order of business on how to do legislation. There's public hearings that they go through, okay, and then so there's a process. And so in accordance with the County Council Rules of Procedure and Organization for the 2016-2018 council term, it states that any member of the council who has a substantial financial and or personal interest, direct or indirect, in any action proposed or pending before the council or a committee shall make full disclosure in writing to the chairperson of such interest prior to the taking of any vote thereon as provided by Section 14-3A of the Hawaii County Charter. Now what I did, I actually make copies of the pertinent rules that apply here, both Rule 10 and Rule 11. Now, Rule 11, paragraph 1, states that you have to make full disclosure. Now, in another portion of that same rule, any member who has a substantial financial and or personal interest directly affected in any action proposed or pending before the council or committee shall refrain from deliberating on said action and shall be excused from voting on matter therein. But it's important to look at the rule further to see what the definition of substantial is. Substantial means an interest which is sufficient in magnitude to influence one's official action. Under the rules, council members must vote unless excused by the chairperson for a stated conflict of interest. Rule 10, paragraph 6 of the rule states, no member shall refrain from voting unless excused by the chairperson for a stated conflict of interest. Now, pursuant to the charter and rules, any alleged incidental or indirect financial and/or personal interest is not a basis for any council member to refrain for deliberating or voting on a matter. So you had heard earlier, council member, David had informed this body, as to what his business is, what his work is, and so in rule, like this under section 14A, all the Hawaiian Charter recognizes that the council members have to operate, but they have rules. So looking at section 14-3A of the Hawaii County Charter, it provides that any member of the council who knows of a personal interest, direct or indirect, in any action proposed or pending before the council shall disclose such interest prior to the taking of any vote. So that makes sense. You disclose it, it's out there, and then they conduct the business, and it's up to the chair at that time to decide, whether the person should refrain or recuse him or herself. I have one example because we had just been last year anyway where council members have been deliberating on increase and decrease in both fuel and real property taxes. Now, as we all know, I'm sure that most of the council members own vehicles, so they would be taxing themselves. Most of the council members that I know of, have real property. So again, it's either a benefit or one burden to them. So it doesn't make sense, in a situation like that they don't get to vote, or nobody's going to vote. So these rules recognize also how government operates in these kind of situations. Now, a failure to disclose a financial and/or personal interest, direct or indirect, could violate Section 14-3 of the Hawaii County Code. There's a case that I cited, Hui Malama Aina o Ko'olau v. Pacaro for Hawaii Act 304 that was decided back in 1983. And in that particular case, there was evidence that a council member, and I didn't want to name the council member, for some personal reasons. Not that I know him, but a council member who failed to disclose an indirect personal interest in a zoning proposal because he would have benefited from the road improvements. So that's a prime example of a council member, receiving a direct benefit. But the court noted that such failure to strictly comply with the disclosure requirement implicitly disqualified the council member until he made the required disclosure. So perhaps if the person had, disclosed it, I'm not sure what the chair is. I mean, what the chair would have done, but the chair could have just said, okay, vote. Why? Because, well, your vote is just one of 9, and for what I know about the voting, this particular situation, we had 6 in favor, which is the majority. In this situation, as I understand from what has been disclosed and what I know about the case, there is no substantial financial and or personal interest directly benefiting Council Member Eoff from her deliberation or voting on Bill 108. So even if Mr. Guzman had made some allegations of such interest, there's nothing substantial about it. Even if you assume a conflict of interest, Council Member Eoff should be able to deliberate and vote on Bill 108 so long as she disclosed in writing prior to deliberation and voting of Bill 108 ownership of the rental unit at Kona Island Inn. This unit is already zoned for hotel and resort type uses. Bill 108 will now require her to re-register the unit as a short-term vacation rental with the planning department. And neither does she gain additional land use privileges from the enactment of Bill 108. Should you have any further questions or comments, please contact me. I'll be sitting right over there. Thank you.
Our next item is communication, specifically a letter from a member of the public dated February 13, 2018, requesting that the Hawaii County Board of Ethics conduct an investigation as to whether a Hawaii Council member violated the Hawaii County Code of Ethics.
Madam Chair, I would ask that we move matter until after petition 2018-03, since a lot of the subject matter is the same. Perhaps there's additional subject matter, but I ask that we take that out of order and move it to after 5B, that we take 5B first.
Okay. That's a motion?
Yes.
Okay, do I hear a second? Second. Any discussion in terms of moving the item?
Points regarding the conflict of interest are in the letter. I think that's very important that those, since I didn't elect to speak also separately, that.
Okay, Mr. Guzman, why don't you come up, please?
At this time, then, I would like to move that we go into executive session for the purpose of consulting with our attorney. There's a matter that has come to my attention that I think we need to discuss first. And we'll get to you. I hate to do this, right? Everyone's here. It should be very short, but if we, I'd like to move into executive session. I think before there's any discussion on this matter, we should go into executive session.
And what is the reason for the executive session?
To
Sorry.
consult with our attorney.
Attorney, okay. So, Mr. Guzman, if you can excuse us, we need a second first and a vote.
I'll second that.
Any discussion? All in favor of going into executive session, say aye.
Aye.
Aye. Any opposed?
My past working relationship with Councilmember Eoff, just for the board's and public's information, back in 2008 when I was council chair, she was part of our staff when I was a council member. And then also in 2012 when I was council chair, she served as the vice chair to the council. So in the past, we've had a working relationship. It's always been that way. There are no financial interests or involvement. There's never been. I reviewed the county code in terms of the conflict of interest provision as well as the fair treatment provision, and I don't see any issues there. But I wanted to bring it to the board's attention and to mention it to the public to make sure that everyone is fully aware of that situation, and of course let the board proceed how it wants to.
Thank you. We appreciate that. What I'd like to do, so we've heard from our counsel in regards to his disclosure about a past working relationship.
No, what he stated is accurate.
All right, thank you very much. Miss,
Sir,
oh,
could
sorry.
we ask you, you have no objection to him serving as our counsel for this matter?
No.
Thank you.
Then I'd also, thank you very much. I'd also like to ask Mr. Guzman if he could please come up and let us know how you heard the disclosure, and we just would like to get your opinion just on that piece now, and then we'll have you come up one more time afterwards, if that's all right.
Yeah, I don't see if that's conflict of interest. Any objection to that.
So you're okay. All right, we appreciate that. Thank you very much. Then, counsel, any
I just would make a motion that there's no conflict of interest and we should proceed with the hearing with Mr. Yoshimoto as our counsel.
I'll second that.
any more discussion?
I'd just say, I looked at the fair treatment provision and the conflict of interest provision of the code. There doesn't appear to be any conflict, as there's no I'll leave it at that, and that's all.
So if there's no further discussion, I call for the question. All in favor say aye.
Aye.
All right, so we found that there's no conflict of interest in regards to Jay advising our Board of Ethics in this matter. It's always a little bit difficult because Hawaii is small and we all run into each other. I've seen Councilman Eoff, at many functions and, that were not directly related to government, for example, privately as well. So we have to just know that as professionals, right, it's our duty to act ethically and to, abide by these codes that are set for us. Mr. Goodnow?
Yeah, just to throw out there, too, I don't think we need to vote on it, but Ms. Eoff did give me a picture, a print, a very pretty print that was done by her husband when I left being county clerk, and it does hang in my house, but, I mean, we really haven't had very much interaction at all. It was, thank you.
Thank you. All right, so we are going to move to a communication, the letter from a member of the public dated February 13, 2018, requesting that the Hawaii County Board of Ethics conduct an investigation as to whether a Hawaii council member violated the Hawaii County Code of Ethics. This letter was submitted by Mr. Guzman. Mr. Guzman, could you please come up one more time? I really appreciate that. Thank you. And just give us your summary, please.
Yeah, there we go. I mean, I can give my summary. I hope everyone on the board has actually read the entire letter, the email exchange, the article in the Hawaii Herald Tribune from February 11th, 2018, which discusses everything in detail. My concern, of course, is that Ms. Eoff does own a transient vacation rental. I did not know this. I sent her an email as is in my letter, asking about this because I had evidence that she had a license for a GE license and a TA license, but that didn't mean that she had one. I had no idea. So that's why I asked her about it, and I asked if it would, not knowing the details of it, where it was or what zone it was in, if she would be grandfathered in or not. I certainly never said it would be grandfathered in. I didn't even know if she had one, honestly. I suspected she did because she had a TA license. And of course her response was that I do not have and have never had a rental of any kind. Please stop sending misinformation. So there was no misinformation in my communication. And as we know, of course, she did have a rental. And I think what she'll try to argue is that she misunderstood what I was asking. I don't know. That doesn't seem valid to me. So there is a concern that, number one, she lied to me as a voter in Hawaii. Not only that she didn't have a vacation rental, but she'd never had any rental of any kind, which seems like a very strong statement for someone to make. And it came across with a great degree of certainty. When she, as someone who is a legislator, and by definition has more power than just a voter, and has power over me in terms of regulating many aspects of my life, the work I do, driving, vacation rental I co-own, all kinds of things. For her to say, stop sending misinformation, I found that an intimidating statement, an attempt on her part to silence me. And I find that quite disturbing. It was also discovered, Ms. Nancy Cook-Lauer discovered that she had not disclosed any income as she's required to from this property. She is, my understanding, the vice chair of the finance committee and a business owner for more than 35 years, but apparently doesn't understand the difference between income and profit, because when she was questioned about this, she said, well, it had never turned a profit, so therefore I didn't disclose any of the income from it. I know that, having just done my taxes, I don't have a profit off of any money I made from my job, vacation rental, my farming. I can't tell the IRS that, well, I'm just not going to put it down here because it wasn't a profit. That wouldn't fly with the IRS, and it shouldn't fly with her statement, and I think it is incumbent on her to provide proof that she has filed GE taxes. What would be evidence of ever having more than $1,000 in income is if she ever had a GE or TA tax filing of $134 or more in any of the years that she's been on the council. If there's evidence that she's paid more than that, that means she's taken in more than $1,000 and would be required to have disclosed that income. She never has. She's also not provided any proof that she has filed her taxes. The statement in the original article is incorrect. Ms. Cook-Lauer just took her word of her saying that she had filed the taxes, but she didn't actually get any evidence, and no proof has been provided that she has. So there's questions not only about whether she should recuse herself or not, but whether it's appropriate for a council member to lie to a member of the public and say that they've never owned any rental of any kind when they know that they have a vacation rental currently. What is also different, I know the lawyer spoke earlier that, well, if you have a car, then you couldn't legislate anything about cars, okay? Well, it's not that you have a car. It's that if you were renting out your car as a business, then yes, if you were proposing legislation that had to do with car rental businesses, you'd have to recuse yourself. If I was on the council as a banana farmer, if I were to pass something that said all other farmers have to register and pay $500 a year to run their farm except banana farmers, that would be a conflict of interest because I would be harming the competition, creating basically a tax that they would have to pay that I would be exempted from, and that's exactly what's happening with Bill 108. She is basically adding a burden to the competition that is outside of these limited resort zones. While she would have to register, the way the bill is written is that her being able to have it as her condo as a vacation rental would continue even if she sells it, whereas there's nothing in the bill to allow anybody else that gets grandfathered in to have one of these things to pass on the license to the next person that purchases that property. So that also, over time, the goal is to lower the number of competing vacation rentals outside of these very exclusive high income, not diverse at all resort zones, like the one that Ms. Eoff has a vacation rental in. That absolutely benefits her as there is less competition. Just like if my vacation rental was there and all the other ones in the neighborhood went away, I could charge a lot more. If I paid nothing and they all had to pay $500 a year, that would be an unfair advantage for me. So it is an unfair advantage for Ms. Eoff, and unfortunately she has not recused herself from this process. I know that she's taken meetings on this issue even since she's asked the board to give her a ruling on whether or not there's a conflict of interest here. I don't know if there's any aspects of the Sunshine Law that were violated. I only brought that up because Ms. David expressed concern several months ago when I was trying to get input from other counselors before this legislation was even proposed, that Ms. David didn't feel it was appropriate for her to comment on it because really no more than 2 counselors, and there were already 2 counselors that were discussing it, so she did not want to be part of that. So, I don't know if any other counselors violated that. I feel like overall that's a minor issue and not something I'm not especially personally informed about is regarding the Sunshine Laws, but I figured those on the ethics board could take a moment and at least consider, was there anything that could have violated Sunshine Laws in this process? So that's pretty much it. I mean, I think it's, there's also, of course, there is an issue. Should she recuse herself? The second issue is, are there any consequences for her lying to someone and saying that she's never owned a rental of any kind and using county funds, county computers to do that? The minor issue of were any Sunshine Laws violated? But ultimately, I think the biggest issue is, did she fail to disclose ever having more than $1,000 of income from this transient vacation rental that she co-owns? That seems very important, and I think, honestly, I think that's the biggest issue here. If public officials are required to disclose income specifically because there could be a conflict of interest in various matters, if they don't do it, and then they get called on by a reporter and they insist that, no, they've never had even $1,000 in income on this property in years, I I find that very, very difficult to believe. And records around GE and tax filings, state and federal income tax filings would show whether or not that statement is true. As a co-owner of a vacation rental, as I put in my letter, you know, even at $79 a night, we brought in more than $1,000 in the first month. So I find it very difficult to believe that in a very high demand, you know, unit at the Kona Islander Inn, that she's never taken in $1,000 in rental income in years. I find that very difficult to believe. So I think it's critical that she explains that and provides independent, verifiable proof to substantiate what she's saying regarding that. Thank you.
Thank you, Mr. Guzman. Do we have any questions?
You know, it's a little unusual. Normally we have petitions,
Yep.
right? Petitions are put on the agenda.
Right.
You've sent a kind of a letter, communication, asking us to investigate,
Yep.
which is fine. My concern, though, is the Sunshine Law. This is listed as a communication. If we were to say, yeah, let's investigate and let's have a vote on that, would we be precluded from doing that because of the Sunshine Law? Would we have to agendize this in a subsequent meeting? I mean, maybe we could make the motion but couldn't vote. You know, and would there be fair notice to Ms. Eoff in the sense, because even though she's here, she has her own petition, that does relate to the conflict of interest, but the issue of the financial disclosure form really isn't addressed in her petition necessarily. So that's kind of something additional. And if we were to take action, I'm a little concerned about proper notice.
Okay, you're asking me a
Yes.
question. Okay, thank you, Mr. Goodnow. Okay, so you make good points. So first of all, notice, due process, right? So you're right that Ms. Eoff would have to have proper notice, enough time to prepare a response, right? As justifiably so. In terms of the conflict of interest, we're already here with her petition, so we're good with that. But the other issues that Mr. Guzman raises, technically speaking and legally speaking, she should be provided appropriate notice. Now, of course, she could waive that if she chose to do so. But on the same token, you know, when the board chooses to investigate, the code allows for the board to petition for an informal advisory. So you could do an investigation on your own, but you're correct. There would be some type of vehicle, like a petition, moving forward. So the request for investigation is appropriate today, and the board can act upon it by saying that it'll agendize it for the next time to conduct further investigation, provide proper notice, or, you know, Ms. Eoff could proceed forward. But, you know, there's several issues. And the most concerning for me would be the petition process itself, because, well, you know, Mr. Goodnow, that Mr. Goodman raises a lot of issues, and so there's significant issues. I don't know if we should ask Ms. Eoff.
Yeah. Well, could I, what I'm thinking maybe after hearing that is, could we defer action on your request at this point and move to the petition for Ms. Eoff, handle that issue, conflict, does she have a conflict? And then we could decide after that if we want to independently investigate other issues that are raised in your letter. Does that sound reasonable? I don't know, would you have an objection to that if we kind of separated it and just did the conflict and her vote?
I don't have it. You know, my concern about that was that I wasn't able to say my piece, and I don't. Has everyone read this and everything?
Yeah,
Okay.
no,
Then that's
yeah.
all I need to. That's all I need to know.
Yeah.
Okay.
I must say though, on the printing on the emails.
Yeah, I know. I wondered if that
very
would
hard,
come through.
especially the one on the second page. If you have a cleaner copy, you could just pass around. I could look at it.
My own
I can't
printed
really
copy,
read
but-
much of that at all.
The
Yeah.
February 8th one.
Yeah.
That one is,
You have an extra copy of
it's
that?
not readable.
It
But
might
it's
just
got to be
that
better than
prints out.
mine. If you could,
Oh yeah, that looks better.
would you
than
mind
yours.
just passing it around and we could take a look?
You can have all of it if you want. I've said I think.
Table
100%.
this matter
And I was
until-
given the same advice by your lawyer too, that you know you were all able to consider an investigation on your own just based on the letter, and that I had the right to petition later if I wanted to.
Yes.
Oh, good. You talked to
Yeah.
Mr. Yoshimoto about that
Yeah.
then. I move that we table this matter until after item number
5B. 5B.
5B.
Second, any discussion in regards to that? All in favor say aye.
Aye.
So thank you, Mr. Guzman. Don't go anywhere.
To our secretary there.
We appreciate it. We will move on based on our most recent vote to number 5B, new business. Petition number 2018-03, request for an informal advisory opinion from a county officer to determine whether there is a conflict of interest by introducing certain legislation before the Hawaii County Council. Ms. Eoff, could you please come up? Aloha again. And if you could please just summarize your petition for the council. Thank you.
Thank you. Although I realize Mr. Guzman's communication is a separate matter, some of his concerns might be addressed during this discussion if you have questions.
I think that was the reason why Mr. Goodnow asked to table the other one. Thank you.
Okay, so as you know, I'm Karen Eoff. I am the vice chair of the council. This is my third term, and previous to serving on the council, I was a legislative staff in the legislative branch. I also staffed the Charter Commission and the Redistricting Commission during that time. And I worked for the previous councilman in Kona as well. So yes, I personally don't believe that I have violated any provisions of the Code of Ethics, the county charter, or our council rules up to this point, and I am here today to find out if the Code of Ethics would prevent me from co-sponsoring this legislation and or discussing it and or voting on it. So that's why I drafted the petition. I took to heart the concerns that were raised, and as soon as they were raised, I did seek some guidance and felt that my best route would be to come here first. So we withheld at the agreement of the co-sponsor, Councilman Kanuha. We asked to withhold the bill because it was going to go on the agenda, and until such time as I can get a clear way to proceed. So I brought copies of the memo that I sent to the chair of the council, if you would like it, that just explains why I asked to withhold the bill at that point in time. So I am the chair of the planning committee, which is, I felt the reason I was approached to take on this legislation, knowing that it's very, or could be very controversial and complex. As was stated earlier in public testimony, which I completely concur with, the bill had been worked on by the administration for almost a year. I had heard about it, but I hadn't had any input in it. I attended a couple of collaborative meetings with different departments because there was a lot of back and forth on how this county would like to proceed to regulate the short-term vacation rentals. And then at one point, I can't remember exactly, but it was the end of towards the end of last year, that the administration actually approached Councilman Kanuha and I and asked if we would consider being the co-sponsors. I think they realized that we would have a better opportunity to answer questions of the public once the information was out there, because it's very, yes, many people will be affected, and there's many people on both sides of the issue that have emailed us and called us, and we have had meetings with various stakeholders to try and get what is actual regulated and what isn't, and what the processes are for those currently operating short-term vacation rentals. The bill itself took a very middle-of-the-road approach as far as we recognize the need for vacation rentals. We recognize that visitors love to stay in them, but we also recognize the need to protect neighborhoods and all of the conflicts that it may cause if it goes unregulated. And so the middle-of-the-road approach was to be able to grandfather in those existing who have currently been paying their GE and TAT, which would be the legal state law that they would need to be doing. If they can show that, then all the current operating vacation rentals, whether they are in a neighborhood, whether they're in residential zoning, or whether they're in ag, would have a process in order to become grandfathered in. Let's see. And as Mr. Takimoto said, it only would apply to those vacation rentals where there is no owner on site. So any other type of rental wouldn't be covered in this bill. And as has been stated, my husband and I do own a small condo unit at the Islander, and it's already an allowable use there. It's not subject to the proposed legislation, and I don't believe I would have any significant financial gain. So as I said, I don't believe I violated any provisions of the Code of Ethics, but I took the concerns to heart and appreciate your guidance in this matter. There is some references in the petition itself that I may not have covered just now, and I'm sure you've read through that, but I did want to address the conflict of interest that Mr. Guzman has pointed out, and as far as our email exchange, which, yes, was very unfortunate. I was involved in another meeting when my staff brought me the email because it was very concerning the way it was written. It was CC'd to all the council members and the mayor, I think, and I don't know if it was the prosecuting attorney, but it was, to me, it was like a global outrage because it was CC'd to the 2 newspapers. And I replied very rapidly on my iPhone. It was a hasty response, which isn't my normal approach to email exchanges, but I did it because it seemed like I better stop this right now because I don't own a vacation rental that would require grandfathering in. And my first read of his email to me was just that. I thought he was accusing me of being in a conflict of interest because I was working on something that would grandfather me in, like a special privilege. But one other thing I wanted to address about what the grandfathering in does, it actually, and this is something we've been discussing, but once a privilege is granted in a certain zoning district, for instance, the grandfathering in of a short-term vacation rental in a residential area, that use would run with the land. So we will, in essence, be allowing these to continue in the areas that it's been operating. I'm not sure if I should address the financial disclosure issue. I didn't mention it in my petition, but and if it doesn't in any way, I'm not trying to address his issue, but I kind of feel compelled to clear that up. And I don't know if you would advise me to go ahead with that or not. It wasn't something I did put in my petition. I wasn't, I don't know why I didn't at that point, but
I'd like to hear from you about that.
Yeah,
and I don't have an attorney with me, and I don't want it to prejudice anything regarding my...
Oh, it's your choice.
So
I mean, technically, this petition isn't dealing with that.
Right,
except
so-
that you have, at this point, now made a disclosure.
Right.
So it's up to you. We're willing, I think, to hear anything, but we leave that to you.
Well, I feel like it's relevant, bringing it up to me that why didn't I disclose the income on my financial disclosures to the clerk's office. I did disclose the ownership of the property on all of my financial disclosures. When it came to the part that is, the directions are to state any income that you received over $1,000, any income over $1,000. And yes, I do pay GE and TAT on a gross income of the condo, as well as my husband's other business. But I didn't understand that to mean gross income, and the net income on the condo is less than $1,000. I also did that for all the way from 2013. I mistakenly understood that to mean net income. I did the same mistake on my husband's income on our business. I didn't report the range of the gross. I reported the range of the net. But we do officially pay all of our federal taxes and our state taxes appropriately. And I know it's not part of this hearing, but I did bring it with me just for the sake of having it. So after that became clear, I did bring that up with Corp Counsel, and they explained to me that, yes, state law requires all income, gross income, to be reported. But our instruction form on our particular disclosure instructions for the county clerk's office doesn't say that. It's vague, or could be misunderstood, which I misunderstood it. So as soon as I realized that was an error. I asked the clerk, what is the appropriate corrective action? And they said I should submit amended reports. So I went back from 2013, and I fixed the proper letter that you put for the range for all of the income that my husband and I have as gross income. So I wanted to explain that. I don't know what the any other remedy is, but I did what I was told by the clerk's office.
Thank you. And Councilmember.
And there was no intention to not disclose 6 years back about a condo unit that I am currently involved in legislation that might or might not be in conflict. So I think that shows that it was just an error on my part, but it wasn't in any way connected to this bill or anything that we're discussing today.
I had just a quick question. This is just more semantics, but in regards to your request, it's generally about the conflict of interest in introducing, but to me, it would also mean in terms of voting for it, right?
Yes, no,
I just want to make sure that somebody doesn't come up and come.
I know that's
so
what
it
it says on the.
by introducing a certain legislation, but it would also be
Exactly.
conflict of interest in terms of voting.
Yes, no, it says introducing on your caption, on your agenda, but in my petition,
Okay.
I've asked, is there anything that prevents me from introducing, discussing, or voting on it?
Okay, so I'm sorry.
So I wanted guidance on all of those things.
We're going to note that on our new.
I noticed that
business.
too on the agenda.
Yeah,
It didn't
just to
say
be,
that.
we're gonna, if that's all right, if we can we kind of correct that agenda item, because it's just important that we have it correctly. So we'll just add that after introducing, on the second line, we'll put the full statement to make sure that there's no questioning afterwards.
Yeah, Madam Chair, we don't really have to amend the agenda. We can just basically note it for the record,
Yeah.
and
Okay.
all interested parties are aware of that. Yeah.
Thank you.
Introducing, discussing, or voting on.
Yeah. So at this point, yeah, we're in discussion.
I have a question.
We can also make a motion.
Oh, could I ask Ms. Eoff a question?
Yes, go ahead.
Or I could
Yeah.
make a motion either way, but, as far as voting, what are the procedures for a council member before a vote when they disclose a potential conflict? What is the procedure at the council level?
Yes, our council rules of procedure state that we are to, if there is a conflict of interest, we are to write a letter to the chair and disclose it out loud to the council members prior to a vote. And then I believe the chairman would either excuse you from voting, or there would be a decision that you can go ahead and vote.
So the chair would decide that, whether you can vote
That's
or
my
not?
understanding.
Because I'm just to clarify that, whether you can vote or not, as far as we as the Board of Ethics can say, well, you're clear to go ahead, right? But ultimately, it's the council chair and ultimately the council itself, its members that make that decision. Is that correct?
That's my understanding.
All right. I don't know, Mr. Yoshimoto, if you've got a lot of experience as council chair.
Well, that's my recollection. So it's different layers, right? I mean, the Board of Ethics interprets the code, and then the council rules address their own procedure.
So if there was a substantive issue about whether something was a conflict or not at the council level, they would discuss that. All right. So with that being said, I'm going to move that our advisory opinion should be that Ms. Councilmember Eoff is allowed to introduce and vote, is not precluded from voting, better put it that way, on, what's the exact language here?
108.
Yeah, the bill 108.
Okay.
Or whatever the bill is. Does it have a bill number yet?
It does, but
Sorry, I should have been more prepared before making my motion. Let me just restate that. I move that we make a determination that Councilmember Eoff can is not precluded from introducing, discussing, or voted on proposed Bill 108 that regulates short-term vacation rentals.
Mr. Yoshimoto? Yeah.
I would advise, since, bills are live documents as currently drafted.
Oh, as currently drafted,
right.
thank you.
Because it could change, and if it
Right.
changes, then they'll, yeah.
All right, do we have a second?
This is for discussion.
Okay, we have a motion and we have a second, and so do we have any further discussion?
I have just a few items I'd like to.
Yes.
I read Mr. Guzman's presentation carefully, and I read your presentation carefully. And he makes some points that I understand, like his concern about the $500 fee for the STVRs as compared to TVRs in resort zone areas, I guess would not be required to do that annual certification. So there would be the unfair competitive advantage, and I can understand that, and the perception that maybe you would support that as a way, there's always, like, perception is not reality. I tell my wife that all the time, but unfortunately she never believes me. But, I can see that. I can see Mr. Guzman's concerns, and then I can see his concern about, the emails that he sent and the responses that he got is, no, I didn't, and then all of a sudden, yes, I do. But I understand that you've corrected that now with the amended annual disclosure, the annual statements. And so I think that's good there. It's just, I can see why Mr. Guzman submitted his concerns to the Ethics Board. I see that clearly, and I think.
Yes, I think it was, like I said, it was a hastily wrote email that I replied because I didn't want the message to go any further that I was somehow grandfathering myself into a law that I was working on. So I think, to be clear, I didn't draft the language of the law that sets out those details.
Right.
The $500 is only because we are going to be allowing for a non-conforming use certificate to be applied for. And so other counties like Kauai charge $750 a year for that. It's because you're granting a privilege. It's not actually becoming a permitted use. It's just a requirement in order to regulate it, that it would help supplement the cost of regulating the program. And the
Right.
planning department said that that was a normal fee that they charge for things. But I just wanted to mention that the bill has to go through, first of all, discussion on the county council among 9 members. It has to be referred to the planning commission, both planning commissions. So certain details like that aren't even set in stone. A lot of the things in the bill, like someone just said, are moving targets. It may not even come out that way.
Right, and I can understand
It was just a
that.
starting point.
Yeah, I'm not arguing as to the structure. I understand why Mr. Guzman, but I just wanted to make that statement that I can see where the perception may not be the reality of what's going to be at the end of the day when the bill's finally done. But I guess my point was that I can understand why Mr. Guzman had his concerns and he brought them to
Yes.
the Ethics Board.
Thank you. Mr. Goodall?
To me, this is the easiest of the issues presented, because the charter, as pointed out by Mr. Kamelamela, makes it quite clear, right, that it provides that as long as there's disclosure, you can vote on anything, right? But you have to disclose it before voting. And the charter trumps everything else. So, I mean, because of that, as long as there's full disclosure, you should be able to vote on anything, even if you thought that, even if there was an interest. So to me, that's more simple, and I ask that be incorporated into our decision, right? To quote Charter Section 14-3, I believe. Which states, any member of the council who knows of a personal interest, direct or indirect, in any action proposed or pending before the council shall disclose such interest prior to taking of any vote thereon. Clearly, it's anticipated that there would be a vote at some point.
And so the amended statements would address that point you just made.
Yeah.
Yes.
Disclosed prior to vote, right?
Right.
So the amended statements.
And you've amended it. Now, there still may be an issue about whether you should have done your disclosure separately. That's a separate issue.
Separate issue.
But on this issue, it seems clear to me that you are okay. I don't know if there's any other else has discussion on that point.
Okay, anything else, Mr. Robertson?
No.
Any other concerns? So yeah, I think the $500 one was one of those things, but my understanding is that that was already in there when it came from the planning department. So it's really, you know, if it was something that you put in there, I would look at that a little bit differently. But if it was something that was drafted, and also, you know, like you said, the bill is still going to go through various levels of scrutiny by different people, and so if that is an issue in general for other people as well, then it's going to be taken up by those people. So, you know, obviously the fact that you, just as you disclose to us, you would also make that disclosure every time it comes in front of your commission, the planning commission, or any other commission. I think that's what is assumed here, but that's kind of, as far as I'm concerned, in this specific matter of the conflict of interest with the specific legislation, I also do not find that there is any conflict of interest, but that disclosure, just to be on the safe side, is prudent.
I would add, too, that under the Fair Treatment Section 283, subsection D, it says, right, nothing herein shall be construed to prohibit an officer from introducing bills and resolutions, serving on committees or making statements or taking action in the exercise of the officer's legislative functions. So clearly that's an exception to the fair treatment section. And then as far as conflict of interest, I believe that too, sorry, find the section here.
We know what you mean.
Well, okay.
I shouldn't, I just listed that no officer or employee shall take any official action directly affecting a business or other undertaking in which the officer or employee has a substantial financial interest. So I don't believe that the legislation would be of any substantial financial interest to me. If you're talking about the registration fee as being applied to some and not others, yes, that was already drafted into the bill. It's up for discussion. It was a starting point that planning was adamant on keeping in because they want to have a mechanism to pay for the program for regulation. And I mean, some people have said that's too much. Some have said it's too little. You know, it's like that's up for discussion at the time that the Planning Commission and the County Council reviews all the details of the bill. But yes, I felt like I was acting within my legislative duties to take this on. Like I said, I became the chair of the Planning Committee this year, or this term, and this seemed like something that someone with a seasoned legislator would need to handle because all of the questions and concerns that have already been raised and that will continue to be raised regarding this. It takes an office, and my office has been, you know, very diligent in trying to answer questions and make sure that the bill is in a presentable form is basically been our role since it was given to us.
Go ahead.
I'd like to just ask one question to kind of follow up because what I've gotten from my review of the material is that your ownership is in a different classification, so
Yes.
it's not affected directly.
Yes, which is
by the
why
bill.
I answered his first email the way I did hastily, is I don't believe that what I own is being regulated by this. It's not being grandfathered in, and it's not a dwelling unit in a residential area, which is, in my perception, what we were tackling with this bill. My condo is in a resort node. It's operated since, I think, '67 as a little mini hotel. I don't advertise it. I don't do anything. I don't manage it. It's like people call the Islander for a reservation and then they assign them a room. So I looked at that as a different animal. And so that's why I replied in a hastily manner. And I'm sorry for that. I know it caused some heartache all the way around. So
That's all right. I depend on my CPA for everything. I don't know anything about taxes, but
Yes.
you know, it might bear thinking about Benjamin Franklin saying it's not enough to do the right thing. You must be perceived to be doing the right thing. So maybe it would be nice to be a little bit more clear and cautious.
Exactly. I think I learned a lot from this.
Thank you.
Thank you. Mr. Goodnow and
So-
Mr. Robertson.
You know, and as far as conflict of interest in the council rules, it does state that you should refrain from deliberating on an action and shall be excused from voting thereon, but it talks about a substantial, and substantial means an interest which is sufficient in magnitude to influence one's action. And that would be up to the council, you know, as the bill goes through the process, right, and let's say it gets amended or whatnot, you still would disclose that to the council, right, that, hey, I have something of an interest. I don't believe it's substantial, and it would be up to them to decide that. Is that correct?
Yes.
All right, so I feel comfortable with, I don't know if our corp counsel wants us, you know, you have to draft the informal advisory opinion. Is there any clarification you'd like from us?
Okay, yes. So in terms of the $500 fee that's in question, I think Mr. Guzman had raised it earlier, right? He basically said that because the short-term vacation rentals that are in the bill are subject to this fee, but those that are not, those that are already in the resort zoning, don't have such a fee. So by application, there's like a unfair advantage. That's what he's saying, right? I mean, I just want to make sure so the board is saying that the fact that the bill was originated from the administration and the details came from the administration, and it didn't come from the council member, then it's okay. Is that, help me here, because I'm trying to
Yeah,
piece it together.
that's my initial thing, and that we don't know if it's gonna it's gonna end up a $500 or not, right? At this point, that's not anything that we can determine because the bill is still moving. Okay? But the fact, as far as I'm concerned, the fact that it was created by the department, the fact that there's precedent, as was mentioned in another testimony earlier, that this is a common practice in other places as well. I think that those two aspects, the common practice of different designations having different application procedures, and then the second part that it was a department, that those are the primary reasons for myself.
Could I add to that? And I have a question for Ms. Eoff. I mean, so let's say this bill doesn't exist or wasn't going to be introduced. Those people that could pay the $500 in the bill to get registered, would they be illegal? Would they be?
Well, right now, residential zoning allows for like single use, family residential or multi. But we've experienced this proliferation of commercial use in residential zoning, which it's not exactly illegal because it's not specified directly in the code, But for instance, when bed and breakfasts became popular years back, we didn't have anything in the code about that. But it became a commercial use of a residential dwelling unit. And so the county began to regulate it. So they require anyone operating a bed and breakfast, which means you live on the property, but you're using your home or a side of your home for a commercial overnight stays, right? We have a bed and breakfast law now, and that must be registered at with the planning department through a planning commission hearing. You actually get permitted for that. At that time, the short-term use of single-family homes on standalone lots became a new popular thing. So now we have this new use of residential dwellings where there's no owner on site. So they're not a bed and breakfast, they're something else, but they're not really an allowable use in residential areas, but they've been continuing to exist because paying GE and TAT is the only really legal thing you can do. And then if you do that, you've been I don't know how to say it, but it's been hard for the planning department to regulate it.
I see.
So by defining it, and all the other counties in the state have defined this use. It's been a problem on all the other islands. We're the last one to try and invoke a program to get a handle on it. There's some other ramifications of the registration process that the state is asking us to adopt a bill like this because they need to identify, for their purposes, collection of GE and TAT where the uses is occurring. So what we're doing by grandfathering in, and there is a fee for that yearly grandfathering, it's called a certificate, non-conforming use certificate, is because we're now looking at you as a non-conforming use in an area that's not really designed for it, but we're offering this non-conforming use certificate so you can continue to operate. We really didn't want to upset this whole industry because there's a lot of economy that's based on it now here on our island. So this was the most fair way to do that, to approach that.
Madam Chair, instead of arguing the merits of 108, because that's, but get to the question of.
The reason I asked that, and I put it to you like this, I mean, is this somewhat, so I have a choice. I'm going to pay the $500 and be acknowledged as a legal entity, or I don't pay the $500. So
you could continue to operate illegal.
And that doesn't affect you. You're already in the zoning. You don't need to worry about that. So it would be something like, well, look, you want to be subdivided, you pay $500 to get subdivided. Just because I own a piece of property that's already been subdivided doesn't mean I get a benefit. I mean, the real point is you're not really receiving a benefit, and I accept that based on what you've said, right?
All right, in that case, then we have.
Sorry, but to me, there's no substantial financial interest in that sense, looking at it from that perspective.
Well,
I mean, you could.
That's.
We've heard it. You made your point. I don't think anybody here is
All
arguing with that.
So we could also put in the informal advisory opinion that we do not see a substantial financial interest.
All right.
Thank
so
you.
Are you amending your motion or
No.
Or no? You keep the motion. Can we, because it's been quite a while since it was stated, can we please hear the motion one more time so that we're all clear on what we're voting on?
I believe my motion was that we issue an informal advisory petition, opinion, that making the determination that Councilmember Eoff can introduce, discuss, or there's no prohibition on Councilmember Eoff introducing, discussing, or voting on proposed Bill 108 as currently drafted. Is
Thank
that
you.
correct?
So that's the petition. We have a second. We've also had a discussion. So I'm calling for the question. All in favor say aye.
Aye.
Aye. Any opposed? So that motion is carried. Thank you very much, Ms. Eoff. I'm assuming we're going back to the agenda item 4A. So if you don't mind just waiting a few more minutes, just in case. Mr. Guzman, could you please come up one more time?
Sure, you would need a motion to remove from the table, Mr.
Okay.
Good, or
Oh, I move that we remove 4A from the table.
Okay, any discussion? All in favor say aye.
Aye.
Aye, all right. So we are back to your communication. So, and I hope you see why it was kind of important to go that route. So I guess what I'm saying is if there are other issues that you feel warrant an investigation, then basically it would be filing that petition so that we can then actually agendize and move forward. Because a letter, is not really the way the process works. Does that make sense, Mr. Guzman?
It does, yes. There were a number of errors in what she said,
Okay.
which is unfortunate again, but that seems to be her MO. She said that her property is not subject to Bill 108, and it absolutely is. She would be required to register it. So that's the truth. She said that the grandfathering in or having the license to run a transient vacation rental would transfer with the sale of the property. That is not true outside of the zones that they're permitted in this legislation. So mine, living in an ag zone, would not transfer if I sold that. And again, that is how it creates an unfair advantage to her, because eventually in other places these would go away. So people would either have to stay in hotels or in vacation rentals like hers in permitted zones. So when she made that statement, that was incorrect, and she knows it because she's the one introducing the bill. There is also nothing currently in the bill to guarantee that a single unit will be grandfathered in. It is incredibly vague, doesn't say what documentation is going to be needed, doesn't say anything about an appeal process, doesn't say anything about how exactly these will be determined, whether or not any of them will be grandfathered in. So based on the legislation that's currently written, there really is nothing to guarantee that even a single unit will be grandfathered in.
So, yeah,
And
Mr.
one
Guzman,
final thing. She
Okay,
also
okay.
said basically that hosted rentals would not be regulated. If somebody lives on the property, that wouldn't be regulated. Well, that's not true either. If someone lives on their property, they're allowed to rent out one room or an ohana on their property. There are many people that live on the property, but they have multiple units and they're renting out multiple rooms. That would not be allowed by Bill 108, and she stated the opposite, that those people are not going to be regulated, and that's simply not true. In fact, even those that have a single room would be regulated because they would be required to register also. So those are at least 3 incorrect statements that she just presented to all of you. My concern, too, is that she seems to be getting a green light, and all future counselors are getting a green light, that they can simply fail to disclose income at any time, as long as at some point they come back and say, well, I just forgot, I misunderstood, even though I've run a business for 35 years, I don't know what income means versus profit. Even though I'm the vice chair of the finance committee, I don't know what income is versus profit, and I simply misunderstood. So if that's okay, then that's okay, and then the board's on record as saying, yeah, in the future, go ahead and hide whatever you want, as long as you come out and disclose it once you're caught.
I appreciate your comments. I just wanted to let you know that if there are that the merit of the bill is not our kuleana right now. That's not our responsibility. And I can see that you have issues with the bill, and there is a process, for you and others to comment as it moves to the legislature, using that process. As far as the other concerns about the financials, if that is a concern, then you need to put that into a petition, and then we can hear that separately. But this was not the issue of petition number 2018-03, which we just heard. So we have not made any determination in regards to that because there has been no petition brought to us. So if that's something that you feel that is concerning to you, then that's one thing. But I'd like to ask counsel, just in terms of the statements that were just made, to clarify.
Okay, to be clear, the board has the ability to also initiate an investigation, so the board can do that as well. So based upon the information provided by Mr. Guzman, the board could also initiate a petition, or it could allow Mr. Guzman to do that as well. So there are 2 options, right? I mean, just to be clear. Mr. Good.
But there's no, difference as far as time. If he did his petition and it went on our next agenda, or we did it and it went on our next agenda, we're still not going to go to the merits of it today because of the Sunshine Law.
Well, yes, because there are due process notice concerns, so it would not be advisable to proceed today. But just to be clear, there are two option tracks. The difference is that if anyone files a petition, then they're a party to the case, and then they have a right to speak, right? If the board initiates it, then the board can determine or call whoever it wants to, but that may or may not include Mr. Guzman. So there's some differences in how you. Go ahead.
Oh, so thank you for that good advice. Mr. Guzman, having heard that, I mean, I'm willing to consider filing a petition and the board doing it, but I think it would be easier on us, and you would also be a party if you filed the petition.
Okay.
Would you be okay with that if we defer taking action on this and you go ahead, file your petition, and we agendize that, in so much as it deals with not whether she can vote or not, because that's been decided.
Right, based on her
But
lies, 4
based
lies
on
that
what
she said.
you concluded with about filing disclosure statements, anything else you want to include?
Am I able to see what she has provided as far as her income so that can be on public record? I mean, I think it's.
That's public
I would-
record, yes.
Okay, is that something I can get access to today before I leave?
Yeah.
Okay, because I'm very curious about
That
what
would
that
be
is.
great. So,
Could I? Oh,
go ahead.
Well, I was
Sorry.
going to move that we,
I just want, if I could, Mr. Guzman, I listened to the 5 points you just made. And the first one about her unit not being subject to, the second one about will not transfer upon sale, the third one about nothing to demonstrate grandfathering, and the fourth one about where you may have one room, or you may have an ohana, or you may have more, and the registering all of those. Those really are the merits of the 108 itself.
Those were all things she said to establish that she had no conflict of interest, and those were not. Those were all incorrect statements that she provided to you all in order to state her case that she had no conflict of interest.
Okay, I understand.
That's
that.
why it isn't the merits of them. It's
Right.
that she just told you for several things that are not true.
Okay. All right.
but follow up on Mr. Robinson's point, though, that those issues, whether you like it or not, right, we dealt with because we're saying, look, she can vote, she can do what she wants on
That's
that.
fine.
It's really the fifth thing that you mentioned that might be a separate petition.
Right.
Focus on that. But given the statement that Mr. Guzman has indicated that he will be filing a petition.
I can make a decision about that, yeah.
Oh,
Yeah.
well, I move that we just close we file communication, the 4A, whatever it is.
Second.
Letter.
Because, I mean, we're just going to file it. We're not going to do anything at this point.
I understand that.
All right.
All right, that's the motion. Do we have a second? Do we have a second? Any further discussion in regards to that? All right,
If I could get a copy of her filings, that would be great.
yes. Okay, then
Thank
all in
you for your
favor say aye.
consideration.
Aye.
Aye.
Thank
Any opposed? So that motion is carried. Thank you, Mr.
Appreciate it.
Guzman.
Thank you.